and welcome to another episode about Who Wants to be Civicillionaire. Our contestant today is a high school student. The topic today will be the Supreme Court case of Gonzales versus Raich. Please welcome Jane from Morton, Illinois. Are you ready to play, Jane?
Bring it on.
First, the basic background information will be read.
Respondents in this case live in California. They use prescribed marijuana to relieve their pain. Doing this was legal based on their state law, but illegal based on Congress's Controlled Substances Act, or CSA. When the federal agents went after them, they sued the federal government. After making its way through the lower courts, it reached the Supreme Court.
The first question is for $1,000. Marijuana was discovered thousands of years ago and made illegal in 1970 by the federal government under CSA. Give me two reasons why this case came up only in 2002.
Well, the first is that research studies at that time showed the effectiveness and safety of using marijuana to treat certain cancer and pain. Therefore, more sick people began to use it. Second, California had legalized marijuana in 1996, making it more accessible to people to use. More people did use it, so that when 2002 came around, it was a common practice.
That is correct. Next question is for $5,000. How did this case get to the Supreme Court?
They sued the Attorney General John for prosecuting them in the district court. They lost. However, the Court of Appeals for the Ninth Circuit reversed and ruled against the Congress for prosecuting these two women. Then the federal government, represented by Attorney General Alberto Gonzales, appealed these rulings to this U.S. Supreme Court, which decided to hear this case on June 6th of 2005.
Right again. Now, for $10,000, what type of case is this and why?
This would be a federalism case because it is an issue of whether the Supreme Court was exceeding its power under the CSA to regulate interstate marijuana activity. The final decision was that the federal law, CSA, could override state law and regulate the state's marijuana activity.
That is correct. Now, for $20,000, what is another example of a similar Supreme Court case?
I'd like to phone my dad.
Get him on the line.
Hello?
Hey, Dad. I have a question for you. What is an example of a similar Supreme Court case to Gonzales versus Raich?
Another federalism case is Wickard versus Filburn. Filburn grew wheat on land for his family. The federal government did not allow this because this would affect the national wheat market. At the Supreme Court level, the federal government won. The court ruled that Congress had not exceeded its power in this case under the Commerce Clause.
Right on the money. For $50,000, what are the arguments from both sides?
The prosecution argued that using the CSA against them would violate the Commerce Clause. In their opinion, growing marijuana in someone's backyard and using it medically has nothing to do with interstate commerce. The area, of course, the federal government can put their foot down. However, the defense argued that marijuana is one of the controlled substances whose intrastate regulation is necessary because it's a part of the larger regulation of economic activity, which is affecting interstate commerce.
That is absolutely right. Now we're going to have a much-deserved break. On the screen, you will see the Friends of the Court's opinions. What is the justice's view on this matter?
The majority opinion was delivered by Stevens. Kennedy, Souter, Ginsburg, Scalia, and Breyer made up the rest of the majority. They ruled that even intrastate cultivation of marijuana for medical purposes will affect the interstate market, so the CSA would still impose controls beyond what is required by California law. Justice Scalia agreed, but for a different reason. He acknowledged what the two women did was intrastate non-economic activity, but the Congress needs the necessary and proper clause to use the Commerce Clause in this case. The minority of justices, including O'Connor, Rehnquist, and Thomas, thought Congress did not have evidence that cultivation of marijuana locally for medical reason will affect interstate commerce. using Thomas's word that if the Congress can regulate these responses medical marijuana usage under the Commerce Clause, then it can regulate virtually anything. The final decision was a 6-3 decision in favor of the national government. O'Connor also offered her opinion that the states should be allowed to experiment as laboratories.
Congratulations, Jane. You made it to the $1 million question. Now the question is, based on expert opinion, do you think this case was decided in the best interest of our country?
Most experts thought this case was not made in the best interest of our country. Don Armentano, a professor in economics at the University of Hartford, said the original intent of the Commerce Clause was to regulate commerce between the states and to prevent the states from blocking the free flow of commerce. The action of the CSA here, though, interferes with the flow of commerce and actually violated the Commerce Clause. Mark Kleinman, on the other hand, a professor in public policy at UCLA, states that the entire structure of the CSA is unconstitutional because Congress has no general power and no delegated authority to regulate what an individual consumes. Therefore, I don't think judicial review worked because Congress has definitely stepped not only into the state's territory, but it has invaded our privacy and basic rights as people to control what we put in our bodies. Many patients out there right now are suffering and they're helpless because of one single decision that took away their ability to use marijuana.
Is that your final answer?
That's my final answer.
That answer is absolutely worthy! Now we got our first Civicillionaire in history of our show.